The Indian judicial system follows the common law system based on recorded judicial precedents, as inherited from the British colonial legacy. The court system of India comprises the Supreme Court of India, the High Courts and subordinate courts at district, municipal and village levels. They form a strict hierarchy of importance, in line with the order of the courts in which they sit, with the Supreme Court of India at the top, followed by high courts of respective states, with district judges sitting in district courts, and magistrates of second class, and civil judge at the bottom. Courts hear criminal and civil cases, including disputes between individuals and the government. The Indian judiciary is independent of the executive and legislative branches of government according to the Constitution. This video highlights each court's structure and competence. Articles 124 to Article 147 of the Constitution of India define the authority of the Supreme Court. The Supreme Court of India is the highest court in the country and the final authority on legal matters. It was established on the 28th of January 1950, taking over from the earlier federal court set up during British rule. Before independence, appeals from Indian courts went to the British Privy Council in London, but now the Supreme Court is the topmost court for all cases in India. The court is located in New Delhi and currently has one Chief Justice and 33 other judges. The court serves as the final court of appeal and has the power to hear cases involving constitutional disputes, fundamental rights violations, and appeals from high courts. Judges enjoy strong constitutional safeguards to ensure judicial independence and can only be removed through a rigorous impeachment process. High courts are the highest judicial body at the state level. Articles 214 to 231 of the Indian Constitution mention about the organization, independence, jurisdiction, powers, and procedures of the high courts. There are 25 high courts in India. The judges of the high courts are appointed by the President of India. While appointing Chief Justice of a high court, the President has to consult the Chief Justice of the Supreme Court and the Governor of the state concerned. While appointing other judges, the President consults the Chief Justice of the Supreme Court, the Chief Justice of the High Court, and Governor of the state concerned. Like the Supreme Court, the High Court has been vested with quite extensive and effective powers. It is the highest court of appeal in the state. It is the protector of the fundamental rights of the citizens. It is vested with the power to interpret the Constitution. Besides, it has supervisory and consultative roles. The High Courts of India enjoy several important jurisdictions. They have original jurisdiction in cases involving state legislatures, marriages, fundamental rights, and transfers from lower courts. Under writ jurisdiction, they can issue orders like habeas corpus and mandamus to protect citizens' rights. High courts also exercise appellate jurisdiction, hearing appeals against decisions from district and sessions courts in civil and criminal matters. As courts of record, their judgments serve as legal precedents, and they can punish for contempt. They have supervisory control over subordinate courts, ensuring proper functioning and even transferring cases. Additionally, high courts possess the power of judicial review, allowing them to examine the constitutionality of government actions, though this term isn't explicitly mentioned in the Constitution. Their authority extends beyond territorial limits if the cause of action arises within their jurisdiction, as reinforced by landmark cases like Chandra Kumar, 1997. These powers make high courts vital guardians of justice and constitutional rights in India. The subordinate courts are so called because of their subordination to the state high court. In each district of India, there are various types of subordinate or lower courts. They are civil courts, criminal courts, and revenue courts. These courts hear civil cases, criminal cases, and revenue cases, respectively. Civil courts hear civil cases pertain to disputes between two or more persons regarding property, breach of agreement or contract, divorce, or landlord-tenant disputes. They do not award any punishment for violation of law, which is not involved in civil cases. The disputes relating to property, succession, ownership, and other such rights come under the jurisdiction of civil courts, which dispose of these cases in accordance with the Civil Procedure Code. Criminal courts hear criminal cases are related to the violation of laws such as theft, dacoity, rape, pickpocketing, physical assault, murder, and so on. These cases are filed in the lower court by the police, on behalf of the state, against the accused. In such cases, the accused, if found guilty, is awarded punishment like fine, imprisonment, or even death sentence. These cases are disposed of by the criminal courts in accordance with the Criminal Procedure Code and Indian Penal Code. Revenue courts deal with cases of land revenue in the state. The highest revenue court in the district is the Board of Revenue. Under it are the courts of commissioners, collectors, tehsildars, and assistant tehsildars. The Board of Revenue hears the final appeals against all the lower revenue courts under it.